All right, so this is the final video on the series on how to resolve foreclosure cases. We talked earlier about short sales, we talked about modifications, we talked about deed in lieu, and we're talking now finally about what is, in my mind, the best way to resolve a foreclosure case, and that is a foreclosure case resolved through trial. Now, throughout the evolution of the foreclosure crisis, there have been various federal and state government responses to this problem that exists across the country, particularly here in the state of Florida. And now that we're long into this crisis, as they call it, we're left with finally the fact that most of these cases should properly be resolved in court. And the reason why I say that is that over years, they've tried various programs, modifications and mediations and different ways to resolve things, but none of them have really worked. And in my mind, the reason for most of that is because the banks just haven't been willing to come to the table with reasonable and responsible settlement solutions. So that gives us no choice. In all of my client interaction, I try to convince my people to work with their servicers as much as possible. I think there's a responsibility to do so. And in some instances, things can be worked out. But in the vast majority of cases, there's simply no way to resolve things other than going to trial and facing the real consequences of a loss at trial. Now, I'm proud that the work that we do in this firm is recognized by both the court and the attorneys on the other side as high-level work. And part of what you get from that is knowing where the real vulnerabilities in each of these cases exist. Now, each case is different, whether it's a trust case and you're being sued by some alphabet soup trust, as we call it, or a servicer, Bayview or SBS or any of the different names that are out there now picking up these defaulted loans, or whether it's one of the mainstream banks, Bank of America, Wells, City, Chase, any of those things. Each of those unique situations presents a different set of circumstances and facts that we use in defending a case properly. Now, you can't just go into litigating these cases with a one-size-fits-all model, and quite frankly, you certainly can't go into these cases litigating each one without going through discovery, without going through real litigation practice that we've become quite good at, quite frankly. Now, when we talked in the earlier series of videos about the different resolution models, whether it be short sale or modification or deed in lieu, we should also keep in mind that even if we ignore and reject all of those options early on or throughout the foreclosure process, that doesn't mean that at the end of the day, we're not going to accept one of those options on terms which are more satisfactory to us. In many ways, the true judge or of a success of this firm is, were we able to get for the consumer a better deal than they otherwise would have gotten had they not hired us at the end of the process? And quite frankly, oftentimes I think that should be the case, frankly, and every time that should be the case. So whether you want to try and resolve the case early through a modification, a short sale, or a deed in lieu, the question is, how much value are we going to add to that by litigating the case properly? And I think often the answer to that question should be quite a bit of value. Now, obviously, the home run in a case is when we go all the way to trial and we win. We get a judgment in favor of the consumer. And that happens more and more, particularly in the older cases that have been pending, because those cases have many problems in a great many instances. Unfortunately, for many consumers, they go without being properly defended. And so many of the problems that existed and would have presented real defenses for that consumer go undefended.